welcome to Legal Munch. This is Dr. Kalpana Jayas. In today's lecture, we would try to understand the nature and application of Article 16 of the Indian Constitution, which talks about equality of opportunity in the matters of public employment. It is a comprehensive examination of constitutional guarantees for equality in public service and evolution of affirmative action jurisprudence in India. The constitutional promise. Indian constitution is a living constitution, which means it is working for the betterment of the society and Indian citizens. So when the framers of our constitution wrote the word equality, they did not intend to it be ornamental. They intended it to be operational, to open the door of power, governance, opportunity to every Indian. There is a trilogy of equality under Article 14, 15, and 16. It forms an interconnected framework that moves from abstract principles to concrete application. It transforms constitutional ideals into lived reality. Article 14, it is a general concept that talks about equality before law, that is foundational philosophy of Indian Constitution. Article 15, prohibition of discrimination on specific grounds. It removes those barriers which has been subsisting in our country since long. Article 16, equality of opportunity in public employment. It is a practical mechanism to ensure that everyone would be treated equally when it comes to giving opportunity in public employment is concerned. Article 16, let's come to the text and structure of this article. Article 16 comprises 6 carefully crafted clauses that work in harmony, not in contradiction. The first 2 clauses establish the principle of formal equality, while clause 3 through 6 introduce substantive equality through permissible reservations and exceptions. So now coming to clause 1 and 2, formal equality, general principles prohibiting discrimination and ensuring equal access to public employment opportunities. Clause 6 to 3, 3 to 6, substantive equality, permissible reservations, and affirmative action mechanism in order to bridge that gap between downtrodden people and well-off people. Article 16, subclause 1 talks about equality of opportunity, constitutional guarantee there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. This foundational clause guarantees equal access to public employment, not equality of outcome. It mandates open competition and prohibits arbitrary selection process. There is one case, C.A. Rajendran versus Union of India, which came in 1968. Equality of opportunity means that every person who is qualified for the post should be considered for appointment. Inclusive merit. Merit remains the constitutional baseline, but courts have clarified it must be inclusive merit that recognizes social disadvantage, not a frozen or exclusionary concept. Article 16, subclause 2 is a negative mandate. Prohibited grounds of discrimination. This clause explicitly prohibits discrimination on specific grounds: religion, race, caste, sex, descent, place of birth, or residence. The key word only, discrimination only these grounds is forbidden. reasonable classifications such as educational classification, qualifications, experience, or physical fitness requirement remain constitutionally valid. Formal versus substantive equality. Treating unequals unequally to achieve real equality is not discrimination, but constitutionally permissible differentiation. In case of State versus Kerala and N.M. Thomas in 1976, this is a landmark judgment marked the evolution from formal equality to substantive equality, recognizing that true equality sometimes requires differential treatment to level the playing field. Article 16, subclause 3, residence requirement, regional balance and national integration. This clause empowers Parliament to prescribe residence requirement for certain posts, ensuring regional representation while preventing narrow parochialism. In Pradeep Jain versus Union of India in 1984, while Supreme Court held, while residence can be relevant consideration to some extent, India must remain one nation. Residence cannot become the passport to opportunity. This clause thus safeguards both regional concerns and national integration, striking a delicate constitutional balance. Article 16, subclause 4, reservation for backward classes. This transformative provision enables a state to reserve post for any backward class of citizens that is not adequately represented in public services. Three essential conditions are there for this reservation. Number one, backward class identification means who are coming under the category or definition of backward classes. There must be a backward class of citizens requiring special consideration. Number two, inadequate representation. This class must be demonstrably unrepresented in government services. Third, empirical foundation. The state must form its opinion based on quantifiable empirical data, not on assumptions. Critically, this is an enabling provision, not a mandatory one, giving states discretion in implementing affirmative policies. In Indra Swani versus Union of India, the case came in 1992, is a turning point when it comes to understanding the structure and nature of Article 16. That is popularly known as Mandal Commission case, fundamentally redefined equality jurisprudence in India, establishing principles that continue to govern reservation policy today. 27% OBC reservation upheld as constitutionally valid for other backward classes. Creamy layer exclusion, that is very important to understand. Economically advanced members of OBC community must be excluded from benefits, means people who are coming as backward classes as caste wise, but are well off when it comes to having resources, jobs, and uh, monetary conditions are fantastic, then they are called as creamy layer and are excluded from the benefit of Article 16, subclause 4. 50% ceiling rule, which is very important. Total reservation should not exceed more than 50%, barring extraordinary circumstances. Promotion limitations. Reservation and promotion was not permitted, Article 16, subclause 4 alone. So Justice V.P. Jeevan Reddy's judgment synthesized equality and social justice, becoming the Magna Carta of reservation law and balancing competing constitutional values. Now, coming to constitutional responses in furtherance of these judgments by Supreme Court of India, Parliament of India brought some important amendments to this article. Following Indra Swani case, Parliament enacted several constitutional amendments demonstrating an ongoing dialogue between judiciary and legislature in refining equality principles. 77th Amendment Act came in 1995, inserted Article 16 subclause 4A, enabling reservation in promotion of scheduled caste and scheduled tribes. Means Indra Swani judgment said there should not be any reservation when it comes to promotions are concerned. So it is constitutional mandate to give reservation to scheduled caste and scheduled tribes as per Article 16, subclause 4A. 81st Amendment, which came in 2000, inserted Article 16 4B, introducing the carry forward rule for unfilled reserved vacancies from previous year. If reserved seats are vacant, then that can be carried forward. A rule was introduced. In 85th Amendment, 2001 allowed consequential seniority in promotions, ensuring that promotions under reservation do not result in junior positions. These amendments embody a constitutional conservation, each branch refining the contours of equality while respecting others' domain. Judicial calibration M. Nagaraj versus and journals in cases. M. Nagaraj versus Union of India. The case came in 2006. Supreme Court upheld the constitutional amendments but introduced rigorous safeguard to ensure reservations serve their intended purpose without compromising efficiency. So, quantifiable backwardness, the state must provide empirical data demonstrating the backwardness of the class seeking reservation, inadequate representation data, concrete evidence must show unrepresentation in public services, administrative efficiency, reservation must maintain the efficiency of administration as mandated by Article 335. Journal Singh case came in 2018. Clarification for SC/ST's backwardness need not to be reproved. This historical disadvantage is constitutionally recognized under Article 16, subclause 4A. However, quantifiable data on representation remain essential for all kinds of reservation. This jurisprudence evolution ensures that affirmative action rests on data, not presumption, grounding constitutional compassion in empirical reality while honoring the lived experience of marginalized communities. With this, I would end here. Happy learning. Thank you.